everybody. Today we have Chris Carmichael, who's going to be talking to us about how to respond to serious injuries on the part of employees. This is a really, really big topic. In fact, we're actually calling this How to Survive a Serious Employee Injury Without Going to Jail or Losing Your Business. Chris, that sounds like a heck of a topic.
It is. Unfortunately, it's a topic that I think a few employers are more aware of than they'd like to be. So we'd like to teach our clients how to avoid that situation. I've been in this business 26 years. I am a damage control specialist and specialize in catastrophic loss management and all that encompasses. I'm a former work comp claims person, which gives me a really well-rounded understanding of what it takes for a successful outcome in one of these cases, all the way through the conclusion of it. I've managed probably hundreds of these serious injuries, and from start to finish. I conduct safety meetings and train to help my clients be proactive and avoid these situations. However, it doesn't always happen that way. The relationships that I have with many of the enforcement personnel that we deal with in the event of these catastrophic injuries, such as Cal OSHA, fire department, police departments, investigators, as well as insurance industry people that become involved. I have wonderful relationships which really benefit my clients and the outcome and the amount of stress and pain that they feel throughout the process. So that's a huge plus for them. Challenging the citations that are issued is a huge part once the initial damage control has started. And in light of the changes that Cal OSHA has made in the last year on how that process is handled, quite differently from how we've seen it over many, many years, is that you need to handle them on the front side rather than the back side. So once a citation is issued, it is very difficult to get it eliminated after the fact, where we now have the opportunity as employers and as professionals to alleviate and eliminate that citation up front so it's never issued, which proves much more cost effective and time effective as well. So I have proved independent employee action and had many of my clients not cited, even in the face of amputations, fires, explosions, falling off of roofs. I've been able to prove that my clients were held harmless and were not negligent or in any way, shape, or form guilty of any wrongdoing. So that's huge victory. It's very, very difficult to prove. It's called a Mercury defense, and it's very, very difficult to prove. But I've very successfully done that, and I'm extremely proud of that. I love to conduct safety audits and compliance audits for my clients to go in, again, to be proactive rather than reactive, which gives them the opportunity and power and empowerment to avoid possible pitfalls when an injury such as this might occur. It's kind of like having your safety gear or your fire extinguisher next to you when soldering. If we do the appropriate audit and make sure that all of our ducks are in a row, so to speak, it eliminates a lot of hassle when something like that occurs. We're prepared, we're ready. And emergency preparedness is the key to success. As far as anything that we find in that audit, we assist the client in implementing the necessary actions. Sometimes that's bringing in vendors. Sometimes that's something that we are obviously always personally involved in. As far as seeing it through, it might be pulling in different safety professionals, different training components. Say if it's doing shoring, I'm going to bring in a company that specializes in shoring because they have the skill set to teach them the correct things. I want to look for weaknesses in their injury and illness prevention programs, their safety training programs, their documentation, because as we all know, if it's not documented, it didn't happen. Even though we might have had 20 people in the room that says it did, if it's not documented and someone didn't sign that they attended it, it didn't happen. I'm also going to look for environmental hazards, equipment hazards, and imminent dangers, and immediately bring those to the client's attention. We call it a mock OSHA inspection, really giving them an idea of what OSHA is going to be looking at when they come out. So it's like kind of putting on my OSHA goggles and going out and looking and saying, okay, this is what they're going to be looking for. Could be extension cords that are frayed. It could be, ladders. It could be any number of things stacked improperly, any unsafe condition that might exist, and sometimes it's an unsafe act that we may witness. And we'll stop what we're doing at that moment, go over and address that with the employer and the employee and explain to them why that act could cause imminent danger or serious injury. OSHA's new process says that we as employers must be reasonable and responsible, meaning that we have done everything reasonably and responsibly to prevent our workers from being injured, to provide them with a safe work environment. If we've done everything reasonably and responsibly to do that, we should fare very well. So in order to do that, doing this mock inspection helps us make sure that we're doing everything reasonably and responsibly. So by us going over the different rules, making sure that all the proper things are in place, that ensures that when OSHA does come out, we can say we were reasonable and responsible, we did this inspection, here's what we did, here's the corrective action, here's what implements we made, and here's our program which meets all of your requirements.
Oh, that's just
along
great.
with training records, which is very important. You can have an IIPP this big, but you better have training records this big. So, and again, documentation is everything. If it's not documented, it didn't happen. The problem that we find with the majority of employers and businesses out there is that they are ill prepared for this type of situation when it occurs. Especially in today's economy, with all the stress, we have fewer people doing more jobs. Things tend to kind of fall through the cracks a little bit more, so we find in our mock inspections and working with employers that this is something that safety kind of tends to go to the wayside first before production or perhaps other things. So the problem is that people make mistakes, they don't prepare, and accidents happen. And there are two things that create an accident. It's either an unsafe condition or an unsafe act caused by a human being. And as we all know, humans make mistakes. And that's really how the problem starts. The problem evolves into more because all of a sudden you have this major accident involving either an amputation, God forbid a death. It could be, anything of serious nature where there disfigurement, could be explosions, it could be any number of types of injuries or accidents that happen, and you're all of a sudden you're thrust into an OSHA investigation you're either completely unfamiliar with or thoroughly unprepared for. So that's huge. That's huge. Very few employers are prepared. They're always surprised when they find out that in the event that they weren't prepared, that they didn't do proper training, or there was this unsafe condition or process that they were aware of and thought, oh no, yeah, we're just gonna do this one time. Nothing's gonna happen. That there can be possible criminal charges filed and people go to jail. And they do. And Cal OSHA has gotten extremely the word I'm looking for, strict and disciplined about this process. Take the case we had in Milpitas with the gentleman who died in a trench, 10-foot trench, 37-year-old man, lost to his family, and criminal charges are being filed against that contractor for not having proper shoring, proper training, and for the position that he put him in, because he was already told once prior to shut that job down and allowed his crew to continue to work. So there's a situation where he knew, and that's where you can go to jail. If you know that you're knowingly putting your workers in danger and think, oh, we're just going to do this once, it'll be fine, and you face criminal charges. And it is up to OSHA whether those charges are filed or not. The biggest problem I see for employers is most employers are very ill prepared for a catastrophic loss or incident. They don't have the necessary documents. They haven't perhaps done the necessary training. There are a lot of things, and they don't have the experience to deal with the authorities and the different people that are going to come into their life rather unexpectedly on how to handle all that. And unfortunately, you can die by the sword or live by the sword, and the sword is your tongue. And so you want to be very careful what you say and how you say it and what you present, because there needs to be a thorough investigation before we start talking. They're most surprised by the fact that criminal charges can be filed in the event that there is serious and willful misconduct, if they have knowingly put their injured workers in harm's way, that they have not exhibited that they are reasonable and responsible employers that have done everything they can to eliminate hazards and allow the worker to do the job safely. I mean, we have lots of employees that are in safety sensitive positions, but if we don't do the appropriate proactive measures, empowerment, education, and preparedness, then we basically are planning to fail. And that's what happens. And it's the enforcement agency's job to bring that out. So you want to be prepared for that, and most employers are not prepared. One of the major things I think most businesses don't realize, and I talk to so many employers, some of my clients, some people that I talk to in the industry that say, you know, I had no idea how this was going to paralyze my business, how this it was like time stopped. We didn't know what to do. It was, you know, like turning around in a circle and not knowing which way to run first. And that's huge. I mean, you're in business to make money and grow your business, and this literally freezes you in time and takes every bit of energy that you have to deal with it, and it's very exhausting. The other thing, the negative press that can accompany this type of accident or injury, if it's high profile, such as the case where we had the gentleman who was killed by the shoring accident, that was all over the news. I would be very hard pressed to find anybody that would ever hire that contractor again. So an incident such as this can really damage the image and reputation of a business you've worked your whole life to build. So it's really important that it's handled correctly. Employers usually don't understand the magnitude of time, energy, money, and stress that goes into handling this type of accident. They can't fathom it because luckily for them, they've never been through it before. Once you go through the pain, you'll never forget it. It's kind of like labor, you know? So you'll never forget it, and it's a tremendous amount that can, for some companies, ultimately put them out of business. So it's very scary. The time involved, obviously, is enormous. It can go, depending upon the magnitude of the case, what's involved and who's involved. If there's litigation involved, it can be years of your life before the nightmare is over. And the other thing is the defense for it is extremely costly and stressful, obviously. And I think the biggest part is the human factor. When no employer ever says, gee, today when we open the doors, let's hurt someone. They never say that. No one ever comes to work with that intention, but it happens. And the feelings that accompany that are horrible. The guilt, the coulda, shoulda, wouldas are very personally and emotionally tolling on someone. And last but not least is the fines that OSHA will impose upon you, and can be in the hundreds of thousands, even millions, depending upon what type of injury and how many people were involved. And then, of course, there are the litigation aspect of it, where in terms of settling the claim, if serious and willful misconduct is filed, that's a whole other set of checks to write that you have no insurance for. I like to explain to you how an incident or accident might flow, what to do, how to handle it, so that you're prepared. And it's basically going to be 2 phone calls. It's going to be, you're going to call 911 first, and I'm your second call. You call me, I respond just as the fire department, the police, the ambulance would. I'm going to be there as quickly and efficiently as possible. And the important thing is to assign one person to handling all aspects, kind of to be the coordinator, if you will, the commander of the case, and handle the accident investigation the emergency response team, the investigators that are going to be dispatched, as well as claims departments, management, your risk management departments, as well as possible involvement with the media. You want one central person handling that so that you don't have 6 different people talking to 6 different people. You want to keep your stories consistent for a number of reasons, because we're here to protect you, and we're here to make sure that your injured worker gets the very best care. So it's important to have that one person handle that, and that is usually myself. We want to launch our accident investigation immediately while it is fresh in the minds of the witnesses, anyone involved. If the injured worker is able to be spoken to, we're going to speak with them as soon as possible. Obviously, after they've received appropriate medical treatment and can speak freely and without trauma. That's always a consideration. If it's been a very traumatic experience, we want to be sensitive to that. So that's all gauged and assessed at the time. We want to interview our witnesses independently and confidentially. This is extremely important, not only to protect their privacy, your privacy, but to get an accurate account of what exactly happened and what they saw. As we know, interpretation is different with each individual. We want to get each person's story, because with each story we may find another piece to the puzzle as to the root cause of that accident or what truly occurred, which can make the difference on whether you're found negligent or not. So the big thing that we do right away when we get there immediately is secure the scene, preserve evidence, just as the police department would do in a crime. We do the same thing. We want to cordon off the area. We want to keep anyone and everyone that is not involved, the rubberneckers, if you will, out of our scene, because we want to preserve any evidence. There could be something that is on the ground that could get kicked by somebody walking through that is a vital piece of evidence. There could be a piece of equipment that somebody moves out of the position it was in, and as we know, Cal OSHA will come in, and part of their assessment and how they fine us sometimes will include a measurement of distance. Well, we don't want something moved 10 feet from where it was, because that 10 feet may make the difference of whether we were cited. If it was here, we wouldn't be cited, and if it's over there, we're cited. So that's very crucial. We want to preserve the integrity of the evidence. I'm going to call Cal OSHA for you. I never ask employers to do this themselves. One, they're usually in a state of panic. They're scared. They don't know what to say. They've never probably called them before. They've never had to call them before. But beware, anytime an employee is taken from your facility by ambulance, that ambulance company has a duty, it's the law, that they must inform Cal OSHA that they just took Joe Smith from ABC Company to the emergency room for a work-related injury. So Cal OSHA is already notified. So if you're an employer and you do not follow up and notify them, first of all, they give you a nice fine to start with. It's $5,000 for not reporting within the 8-hour period, which is 8 hours from your moment of knowledge that somebody is, carted off. And they'll really look at you hard if we don't report in a timely manner, if we don't come to the forefront and say, geez, we had this happen. So it's very important that we do that. So I like to do that for my clients. I also know the operators that work on the Cal OSHA call line. There's one gal I talk to regularly. We're on a very first name basis. So when I call her, she knows that when I report in that what I'm saying is true as can be of the knowledge I have so far. And it also helps make sure that we get the right inspectors on our projects. I carry an incident kit. That kit will include a hard hat, boots, safety glasses, gloves, caution tape, where I'm going to cord off the scene, do not cross, kind of like the police tape. It's going to include a camera. Sometimes it's the camera on the phone. It depends on, sometimes that battery is not charged. I'm going to use whatever camera is available to me. a flashlight so that if I have to get underneath and look at something, and as I've had to in many cases, or look at a piece of equipment, I have the ability to do so, which doesn't cause delays. Time is of the essence in these situations usually. And it's my goal to get out there hopefully before all the enforcement does, if possible. If not, we work in tandem with enforcement to make sure that we get the best possible outcome. Our goal is to find the cause of the accident for a number of reasons. One, we want to protect you, the employer. Number two, we want to protect your employees, and we want to make sure that we give you the ability to learn from the mistake and keep it from ever happening again. So there's a multifaceted reason for finding a root cause, and then give you the appropriate tools to train to prevent that from ever happening again. Maybe it's a program, maybe it's training, it's a combination of thereof, so that you can keep it, be proactive. We're going to notify the injured worker's family. Sometimes that's a personal visit. I've done it 3:30 in the morning, knocking on a door. Sometimes it's a phone call, depending on how close how close in vicinity the family is to where the accident has occurred, and how easy it is to get a hold of them. Sometimes we don't have updated records. We may not have a good phone number, and I've got to search, address, internet. I mean, we've done multiple things where you go, okay, we've got to find this guy's family. And in many cases, the injured worker can't tell you because perhaps they're unconscious or, incapacitated due to injury. We're going to, again, interview the witnesses immediately and separately. We're going to ask for all of the necessary documents, training records, programs, and things that would, maybe maintenance records if a piece of equipment's involved. We're going to want to look at all of that and pull all that together so we can be prepared for Cal OSHA coming out. We're going to work with your legal counsel to protect attorney-client privilege. In probably 95% of the cases that I work on, I will generally, after the initial response and that initial damage control, preserving the scene and doing all this, I'll tell my client, get a hold of your attorney, have them come out, bring me a contract. I now work for them. What that does is it protects your right to privacy, and my work product then becomes attorney-client privilege and cannot be used against you in a court of law, which is very, very important. Very important. We will create for Cal OSHA an accident investigation binder, much like one of these, that is completely organized, tabbed, collated, addresses every request, because when Cal OSHA comes out, they're going to give you a document request sheet. We're going to give them everything they ask for and nothing more. It's kind of like when you testify in a court of law, answer only when asked. That's exactly what we do in terms of a Cal OSHA investigation. You only give them what they ask for, but we make sure that it is done in its entirety, completely, efficiently, and in the time frame that they allow, because they give you a deadline to produce all those documents. So we handle all of that for you and deliver it as well, and make sure that all the necessary documentation that we did our jobs in the time we were supposed to do them is all preserved and kept, so that should anything change as the process goes on, which it can, photos can pop up. Like when we preserve the scene, I'm going to take photos in tandem with the OSHA inspector. And people always ask me, well, why? And I have to say our OSHA inspectors give me their photos because as employers, we have the right to subpoena their file. I usually get them without subpoena because we share. And that's really, it's an exchange between us and OSHA. We never want to appear that you're hiding anything. So when you work as a team with them, it changes the whole nature and tone of the investigation. And I urge you, never lie to them. Never ever lie to them. So we handle all of that process from start to finish, and keep you, of course, abreast of everything. But we allow you to remain running your business, growing your business, dealing with your day-to-day operations, and we handle the catastrophic loss management. I would like to explain to you what serious and willful misconduct is. Serious and willful misconduct means, basically in a nutshell, that we knew of a dangerous condition or danger and failed to take corrective action. And when I say failed to take corrective action, that could include education, appropriate training. Anytime we have a new process or piece of equipment that we bring into our environment that we work in, we have a duty as employers to educate, train our employees on how to safely do the process, work the equipment, whatever it may be. If we don't do that, we're found serious and willful misconduct, which means we knowingly let somebody operate a chainsaw without showing them how. It's like put it this way, you take your teenager and instead of putting them through driver's ed, you set them in the car and say, go on that freeway, have fun. It's the same thing. It's like driving without a seatbelt, basically. And what happens when you do those things is accidents happen. You don't prepare, you don't empower, you don't educate, accidents happen and people get hurt. So that's basically what serious and willful misconduct is. The problem with serious and willful misconduct is it's generally gross negligence. Many attorneys think it's just a great thing to add on to any work comp claim. It results in criminal charges that can be filed. And it is Cal OSHA that decides in their investigation if you were negligent and willful enough and the injury was that bad to refer it for criminal charges. And you have no control, no power over that. That is up to a state-run agency that's going to decide your fate. And the implications of that, the cost of that personally, professionally, and emotionally are beyond comprehension. Absolutely. It also puts you in a position where you're uninsurable. When an insurance carrier looks at you from an underwriting perspective, they look and say, whoa, these people have these citations, and my God, they've got 6 serious violations, serious and willful. I earlier mentioned attorneys loving serious and willful misconduct. The reason for that is they work on contingency, and it raises the value of the case. It's a means to add more value to the case for them because they work based off percentages. So the higher the number, the higher percentage for them. So there's an incentive for the applicant attorneys out there to throw this into the mix. And the problem is the burden of proof is on the employee, but it is also on us, the employer, to prove that we did all of the appropriate training, education, and maintenance, all sorts of things that we have to do as employers. You know, in California, we have a list a mile long as employers of what we have to do. The list for an employee is about that big. So we have a lot to prove that we did our jobs and that we did them correctly and that we communicated effectively. We live in an extremely multilingual state. So if you have multilingual employees, you must communicate in their language. I saw a case many years ago where an employer had done a ton of documentation and training, but unfortunately, not in a language that that particular employee could understand. And they lost. They fought it, and they lost. And the value of a serious and willful claim added to a workers' comp claim is half the value of all benefits combined. Conduct a careful analysis of your liability. This is huge, because when we do the response to the accident, as we do the accident investigation, I kind of refer to these accidents, they're like onions. As you peel the layers of the onion back, the tears start to flow and it starts to stink at times. So it's really important that we make sure that we assess what our liabilities are, what they may be as evidence presents itself. What we know today may change tomorrow. It may change 2 weeks from now. In a case I worked on a while ago, it changed 4 months after the incident occurred. So it's extremely important to make sure that you peel your onion correctly and that you assess the liability and make your decisions from an educated standpoint and with the advice of counsel, because they're going to tell you yes or no. A lot of us get caught on principle, but that's not fair, it's not so. But if you don't have the documentation that says you did that, it's our word against his. Like, hire a powerful attorney who specializes in this. You want to go to the big guns. You want to go to those who specialize in this type of OSHA investigations, injuries, and accidents, and defending you on serious and willful. It's crucial to the outcome for you. To kind of wrap it up, we've talked about how to survive a serious accident or injury. We've talked about the problems that occur as a result of these accidents or injuries. We've talked about the process, the flow of how it goes, what to expect. And then we've talked about how to handle one of the results, which is serious and willful misconduct, which is very real and very expensive and very costly in many respects. We have talked about having the right people on your team, and that is huge. You know, you don't go into the Super Bowl with the Pee Wee team. You go in with the A team, and that's very important. And you want the right people on your side, because it is your interest and the interest of your employees that is most important. Most employers don't realize that they have a ticking bomb in the attic and in the basement, and it is a matter of time as to when that bomb goes off, or I refer to it as the elephant in the room. And we all may say, yeah, I really know I need to fix that or do this, or we need to do that, and gosh, we should do this training. Well, these bombs are there ticking, waiting to go off. And we're here to help you prepare to diffuse those bombs and make sure that you're ready in the event of something happening. I want to teach our clients to be proactive instead of reactive. It's always easier to be proactive than reactive, because I think in the case where a crisis and chaos happens, people panic and additional mistakes are made beyond the actual accident or injury that occurs. Invite me in for a visit. Let me be there. Let me help you. Let me get to know your business. I pride myself on really becoming part of your organization. It's really funny. Most of my clients, employees, think that I work there. They don't realize that I'm their broker or consultant. They think I work for the company they work for. So I really become an integral part of your operation. I blend in, and I'm there to help. I'm there to keep you and your employees safe and make sure that you can go home at the end of every day feeling good about what you do, not guilty. And I like making sure that you feel protected and knowing that you have your own personal fire department. We respond 24 hours a day, 7 days a week. I know no one else that does that. There are times I get a phone call at 9 o'clock at night. Sometimes it's 3 in the morning. Sometimes it's 5 in the afternoon. It depends. But when the bat signal gets put up and the bat phone rings, as they say, I respond, and that's what really makes the difference. And I can be in a meeting and say, I'm sorry, I have to excuse myself, I have to go, and I'm out the door. And I think you'll feel better knowing that we're on your side and that we are dedicated and committed in your safety of your business and your employees is our priority.